Welcome to another online PowerPoint presentation. I am Stephen Thiele, Partner and Director of Legal Research at Gardiner Roberts. I have been a research lawyer for almost 30 years. In this presentation, I will be discussing issues related to limitation periods in Ontario and some of the procedural changes that have been adopted by the courts, particularly with respect to civil litigation matters as a result of the COVID-19 health emergency. There have obviously been some procedural changes in the criminal justice system and family law matters as well. However, I will not be discussing all of those changes in this presentation due to time, and viewers are directed to the appropriate Ontario Superior Courts of Justice and Ontario Courts of Justice websites for more information. I will provide those URL addresses, however, later in this presentation. We certainly live in unprecedented times in which our normal daily routines have been interrupted by a virus that has spread globally and has significantly disrupted the economy. Our federal and provincial governments, like other governments around the world, have been forced to respond to the pandemic caused by COVID-19 and have been required to invoke a state of emergency. In Ontario, the state of emergency was declared on March 17, 2020, under the Emergency Management and Civil Protection Act. Under this act, the Ontario government moved quickly to approve regulations through Cabinet in relation to various issues, including issues related to the criminal and civil justice systems. One of those regulations, which was put into effect 3 days after the emergency was declared, was Regulation 7320. It is under this regulation that limitation periods in Ontario were frozen and in which directions were given concerning the time periods and deadlines under the court rules. With respect to limitation periods, the starting point is Section 7.12 of the Act. Under this provision, the Ontario government possessed the authority to temporarily suspend the operation of a provision of a statute, regulation, rule, bylaw, or order of the government, and where appropriate to set out a replacement provision to be in effect during the temporary suspension period. Under Section 1 of the regulation, the Ontario government did exactly what Section 7.12 of the Act permitted it to do by suspending for the duration of the health emergency, retroactive to Monday, March 16, 2020, any provision of any statute, regulation, rule, bylaw, or order of the Government of Ontario establishing any limitation period. However, it should be noted that this provision does not suspend time deadlines where there is no statute, regulation, rule, bylaw, or order of government at issue. So, for example, time periods in contracts are not suspended. Thus, where parties are concerned about a contractual time period, they will need to renegotiate the contract or enter into a tolling or a standstill agreement. Now, limitation periods were not the only things impacted by Regulation 7320. Under Section 2 of the regulation, the government directed that any provision of any statute, regulation, rule, bylaw, or order of government of Ontario establishing any period of time within which any step must be taken in any proceeding in Ontario, including any intended proceeding, shall, subject to the discretion of the court, tribunal, or other decision maker responsible for the proceeding, be suspended for the duration of the emergency, and that suspension is to be retroactive to March 16th. The wording of this provision has raised some controversy, and therefore it is important to consult official sources, including specific tribunal websites, to determine how this provision is being interpreted. It is this provision that resulted in the Landlord-Tenant Board canceling all residential tenancy evictions. It is this provision that caused the Ontario Local Planning Appeal Tribunal, however, to initially say that its deadlines under tribunal-approved procedural orders remained in effect. Now that has been changed. Returning to limitation periods, in Ontario, the Limitations Act 2002 establishes a basic limitation period of 2 years. This basic period can be found in Section 4 of the Act. This basic 2-year limitation period is subject to discoverability. Initially, many lawyers were of the view that the Act's discoverability section, which is Section 5, was merely a codification of the common law principle of discovery that applied to limitation periods before the Act came into force. However, as courts more closely examined the provision, it was found that the Act's discoverability provision went beyond the common law principle. In particular, subparagraph 4 under Section 5.1 permits delay in the commencement of the running of the limitation period, where it is based on whether it would be appropriate for a party to seek a remedy having regard to the nature of the injury, loss, or damage. Some circumstances in which this provision might delay the commencement of a proceeding is where parties are in a continuing relationship, and it would simply not make sense to start a lawsuit over a matter which would cause irreparable harm to that relationship. A leading case on this issue is the Ontario Court of Appeal decision in 407 ETR Concession Company v. Day. In this case, Justice Laskin observed that whether resort to litigation would be appropriate depends on the specific factual or statutory setting of each individual case, including taking into account the particular interests and circumstances of the plaintiff. Under the Act, there is also an ultimate 15-year limitation period in which a person is required to bring an action. If a particular matter arose more than 15 years ago, then in general a claim on that matter will have expired. Individuals and corporations have the right to ensure that there is finality with respect to potential past wrongs, and therefore the ultimate limitation period ensures this finality. But under Section 16 of the Act, there are also circumstances where there is no limitation period. For example, there is no limitation period in respect of an action based on a sexual assault or unspecified assaults on minors. Under Section 19 of the Act, special limitation periods established under other acts have been preserved. So, for example, the special limitation period that applies under Section 38.3 of the Trustee Act is preserved. This section deals with claims by or against an estate. Under the Libel and Slander Act, there is a special limitation period for certain defamation actions. This is preserved. All of the acts in which a special limitation period is preserved are listed in a schedule to the Limitations Act. It should be noted, however, that certain statutes are exempt from the application of the Limitations Act, such as the Real Property Limitations Act, which contains longer limitation periods. For example, a claim for a constructive trust in property is subject to a 10-year limitation period. Now, let's move on to some other issues related to the court and how civil litigation has currently been impacted by COVID-19. On March 17, 2020, all regular operations of the Ontario Superior Court of Justice were suspended for all non-urgent matters scheduled on or after March 17th. Only urgent and emergency matters could be heard. What constitutes an urgent or an emergency matter was divided into categories, some of which were urgent and emergency matters related to public health and safety and COVID-19 specifically, and matters related to family and child protection. Now, with respect to civil and commercial list matters, urgent matters are those where there are time-sensitive motions and applications where immediate and significant financial repercussions might result if there is no judicial hearing, where there is an outstanding warrant issued in relation to a small claims court or superior court civil proceeding, or any other matter that the Superior Court of Justice deems necessary and appropriate to hear on an urgent basis. This basket clause, however, will be strictly limited. Once a court has determined that a matter is urgent, it is not open for the opposite party to challenge that finding. In a recent decision, Justice Myers was critical of lawyers who were clogging up the court's email system with back-and-forth submissions on whether or not a matter was urgent. He clearly expressed that this must stop. His Honor stated that submissions on the merits and emails arguing back and forth among other lawyers about urgency should not be sent to the court unless invited, and that once a civil matter was booked under the notice to the profession, particularly in Toronto, there was no basis for further submissions to be delivered on the issue of urgency. For the Toronto commercial list, matters that will be considered to be urgent or time-sensitive will be those in the following categories: initial orders under the CCAA, CCAA stay extensions, receivership applications, plans of arrangements, injunctions, approval and vesting orders, and urgent bankruptcy applications. Recently, the Ontario Superior Court of Justice added more matters to the list of matters that can be dealt with. These matters are select pretrial conferences, Rule 7 applications, Rule 7 motions, and other applications and motions in writing that are proceeding on consent of all parties. To qualify for a pretrial conference, the court is prioritizing those conferences that were canceled between March 16th and May 31st, 2020, due to the closure of the courts. Further, to get a pretrial conference, all lawyers and all unrepresented parties must confirm in writing that the case is trial ready, and there must be a commitment to attend remotely with the full intention and authority to settle the case, and that there is no obstacle to resolution of the case, such as an outstanding expert report, outstanding productions, or other missing evidence that is critical to the case to settle. Rule 7 deals with matters where there are parties under a disability who in general are required to litigate by representatives. So the COVID-19 health emergency has required our courts to adapt. Notices to the profession and the public contain valuable information, not just about the matters that will be heard, but with respect to court procedures, including criminal procedures and family law matters. All this information is available online and can be easily accessed through the website displayed on this slide. The primary site is www.ontariocourts.ca. So I do urge you as a viewer to access each of the notices to the profession and the public to understand what the court will be hearing and how to get a hearing before either the civil courts, the family courts, or how hearings are working in the criminal justice system. Thanks for watching this presentation. Matters involving limitation periods and procedural time periods are of significant importance. This presentation is not intended to be legal advice and does not necessarily represent the views of Gardiner Roberts LLP. You should always consult a lawyer when seeking or needing legal advice.